Testing, testing. Okay, welcome to the Public Service Commission's administrative meeting for April 2nd, 2025. First item is approve the minutes of our meeting of March 26th, 2025. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Morning, Mr. Chair. There's one consent item today. It's an application from JT Consulting for a license to supply electricity.
All right, I move we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff, and direct the company to notify the commission within 30 days of any change in the information in the application. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
And for the administrative agenda, we're going to take item number 2 last, which brings us to item number 3, which is an application from the Potomac Edison Company for authorization of the issuance of long-term debt.
Good morning, Chair Hoover and members of the Commission. Oladipo Fade on behalf of staff. On February 18th, 2025, Potomac Edison filed an application for the authorization of the issuance of up to $425 million principal amount of long-term debt. If approved, Potomac Edison will use the proceeds to refund obligations on existing bonds, to fund capital expenditures, and for general corporate purposes. Recognizing that Potomac Edison has only 2 members on its board, the company also requests a good cause waiver of Article 12 of COMAR 2007-04-02A, which requires affidavits from 3 members of the board. Staff's reviewed the company's application and finds it compliant with the requirements of COMAR, which outline the process by which public utility companies can apply for the authority to issue financial securities. Staff recommends that the Commission grant the application and issue a final order in compliance with COMAR 2007-0402C, authorizing Potomac Edison to issue up to $425 million of long-term debt and grant a good cause waiver of 2007-0402A, Article 12. Thank you.
So, any questions for staff? All right.
Good morning, Mr. Chair and Commissioners. Joseph Curran on behalf of Potomac Edison. We prepared their application for them and had an opportunity to work with staff on their questions, and hopefully it's to the Commission's satisfaction as well.
Any questions for PE? All right, with that, I move we grant the company's application and issue a final order in compliance with COMAR 20.07.04.02C, authorizing Potomac Edison to issue up to $425 million principal amount of long-term debt and grant a good cause waiver for COMAR 20.07.04.02A, subpart 12. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 4 is a request from Dent Instruments, Inc. for approval of the Power Scout meter family.
Morning. Good morning, Mr. Chair, Commissioners. Michael Spiegelman on behalf of staff. This item concerns a request by Dent Instruments filed on February 10, 2025 for approval of the Power Scout solid-state electric meter family, manufactured by Dent Instruments for electric, residential, and commercial submetering application. Specifically, the application requests approval of models PS3HD, PS12HD, PS24HD, and PS48HD. Public Utility Article 7-301A requires a person to gain Commission authorization before use of gas or electric meter, and POA Section 7-304D4 at 1 and at 2 state that all submeter equipment is subject to regulations and standards adopted by the Commission for accuracy, testing, and record keeping of gas or electric company meters. COMAR 2025-01-04A further requires that first, all submeters installed in compliance with these regulations be of type and class to properly and accurately register electrical consumption. Second, the meter type and design shall meet the applicable provisions of the latest edition of the American National Standard for Electric Meters Code for Electrical Metering, the NZC 12 standards. And three, that sub-meter installed for billing purposes be approved by the Commission. In the present filing, Dent Instruments has provided documentations that this family of meters has been tested and confirmed to all applicable NZC 12 standards for electric meters as required by COMER. In addition, the Power Scout meter family is already approved by California and New York Public Service Commission. Therefore, staff recommends that the Commission approve Dent Instruments' request to approve the Power Scout family solid-state energy meters manufactured by Dent Instruments for residential and commercial electric submetering application as stated on page 3 of staff comments. If approved, staff will update the list of approved devices located on PSC website. Thank you.
Okay, any questions for staff? I take it there's nobody here from Dent Instruments, right? Okay, all right.
Okay, well then, Mr. Chair, I actually had hoped to ask a question of the company, so perhaps you could answer this. And this is actually just for just information, mostly because we've been hearing from stakeholders about the value of submetering. So you've reviewed all the materials, and have they included in the materials the kinds of applications that they would like to use for these particular projects? Could you just go into a little bit of detail about that?
Well, this is basically going to be used in residential or commercial applications, so anybody can use any.
Right, and what would be the value of this particular product?
Can you explain your question?
Well, I mean, we've heard about the ability to target certain devices within a home. So you can target hot water heaters, or you can to be able to just turn those off as opposed to the house as a whole. Is that the kind of applications this technology would?
This particular meter would be able to capture total energy consumption for the apartment or condo unit.
So this is for apartments that have a master meter, and this would be submetering in this context.
Yeah, it can be used for that, or just a separate meter for each individual apartment.
Okay. All right. Thank you.
Okay, anybody else? Seeing none. All right, I move we grant the company's request to approve the PS3 HD, PS12 HD, PS24 HD, and PS48 HD models, solid-state electric meters manufactured by Dent Instruments for electric, residential, and commercial submetering applications. Commissioner Sussman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
And today's final item is item number 2, a request from Arcadia Power, Inc.
Good morning, Chair and Commissioners. Harrison Scher, Lloyd Spivak, and Paige Shaw on behalf of staff. Philip Vanderhayden, the Net Metering Working Group Leader, is also present to address any policy or technical questions. Arcadia began contacting staff informally in late 2023 requesting a modification of its bonding requirement for participation in the Community Solar Program as a subscription coordinator. In May 2024, Arcadia filed the instant request to modify its bonding requirement to a set amount of $100,000. Additional attempts to resolve the matter informally were ultimately not successful. It is staff's position that the current bonding structure is necessary for customer protection. If granted by the Commission, Arcadia's request to modify its bonding requirement would result in insufficient assurance of required customer protections. Strong financial stakes and customer protection are essential for this emerging industry, as customers are often unfamiliar with contract terms and may be hesitant to contract without knowing that their rights are well protected by the Commission's financial controls. The community solar bonding requirement is required of both types of customer-facing solar companies, which are subscriber organizations, or SOs, and subscription coordinators, SCs. Both types are subject to the Commission's authority. As companies with retail exposure, each must follow regulations, including those for customer protection. Although an SC may function on behalf of an SO, an SC is authorized separately as a program participant. An SO bond is not written in a manner that indicates it could be drawn upon to satisfy a claim against an SC. Bonds ensure the regulatory compliance of each organization and are not associated solely with their physical assets, which would include solar plants. A number of solar industry organizations have filed comments arguing that subscription coordinators' obligations are covered by the subscription organization bonds and that SC bonding is therefore redundant. Staff disagrees. For example, as an SC, Arcadia is responsible for contracting with customers to participate in community solar projects. This entails handling payments for subscribers, applying discounts to subscribers' utility bills, remitting subscription fees to subscription organizations. Additionally, Arcadia also remits remaining utility charges to the utility on behalf of customers. The bond is structured to satisfy Arcadia's financial obligations to the Commission or other government entities. Additionally, the bond may be used for payment of Maryland court judgments against Arcadia. The bond provides vital protections for customers, and should Arcadia become unable or unwilling to meet its financial obligations, it can be drawn upon. SC and SO bonds scale with the amount of solar capacity controlled in the program. Staff estimates that bond premiums represent less than 1% of the value of subscribed energy and likely are in the single-digit percentages of an SC's management fees. These amounts do not appear to impede business and are equally imposed on all participants for the benefit of subscribers. As evidenced by the growth in applications and operating projects, the community solar program does not appear to be inhibited by the bonding requirements, which have now been in place since 2022. At the time the SC application was developed, the bonding mechanism was internally reviewed prior to being posted on the Commission's website at the Commission's direction. Staff recommends that the Commission maintain the existing bonding requirements and structure, and we are available for questions.
Okay, before we turn to questions from staff, I noticed all the filings had confidential information. And so what I need to get clear is the confidential information is literally just the numbers, correct?
Yes, for the most part, the numbers.
Okay, all right. So if we stay away from citing specific numbers, we can ask whatever we want. So,
Right.
okay, so any questions for staff? Commissioner Sushman.
Morning, Mr. Chair. In looking at other states, the argument is that bonding requirements are required only in Delaware and that the bonding amount is relatively low. Do you have, I mean, you know, they're arguing that there's just too much bonding because it's you're getting bonding from the SO and you're getting bonding from the SC. In the other states, they've sort of made the decision not to require bonding, or a small amount. Do you have any comments on that?
Yeah, staff is concerned that the other states wouldn't have similar consumer protections. I think consumer protection is something this state values, and that's something to be proud of. As SCs continue to scale in size, it's important to have the appropriate assurances in place for customer protection.
Okay, so give me an example. So you have an SO that has what we think is an appropriate level of bonding at this point. So give me an example of a situation where a customer would have a problem and not be able to seek redress if the SC were not bonded.
So in a situation where Arcadia or any SC would become insolvent and be unable to meet its financial obligations, the bond would provide the assurances that any money that the customer may be owed could be met, and that can be recovered through a Maryland court judgment.
Okay, so in that situation, what would be the SC's financial obligations? I mean, the SC sort of is, well, maybe you can,
Here,
Actually,
it's a little hard for us to say specifically what the SC's subscriber coordinations, what their specific financial requirements would be, because that's going to depend very much on the structure of the contractual relationships between the subscriber organization, the subscription coordinator, and the customer. I mean, you have a three-way set of interests there. And it is very possible in any given situation that the customer is not going to have the direct relationship with the SO, or that the SO is not going to be the company that actually committed whatever the problem is, whatever is causing the customer to have the complaint or the problem or the debt, whatever the debt to the customer might be. It is all, if the customer doesn't have that contractual right under whatever their agreement is with the SO, but they have it with the SC, that's when they would need to draw on a bond from the SC.
okay. So perhaps, I'm assuming Mr. Wallace is going to be coming up, and there you go. You'll be able to respond to that. The argument was also that the amount is too high and could serve to discourage other SCs from coming into the market. It clearly hasn't happened for Arcadia, but it's a pretty big company. But for smaller companies, is it possible that the bonding requirement's too high? So that's, I mean, I know that we're sort of considering both questions, the question about bonding, the necessity for bonding, but also whether the bonding amount is too high.
I'll let Mr. Vanderheyden speak to that because he has more knowledge on that specific subject.
Good morning, Commissioner, and on behalf of the work group, thank you for posting our new regulations for hearing in 30 days, so we can get that part of the consolidated billing working. Your Honor, the bonding scales with the megawatts in the program. The bonds we're talking about are surety bonds, which is basically a performance bond. So you're looking at premiums on the face value that's like 1 to 3%. So if you have a $25,000 bond, at 1%, that's $250. At 3%, it's $750. So a 2 megawatt facility, a small company that starts, they're going to bond for the first megawatt's 10,000. That was done in case there were really small organizations that were involved. But they're going to have $35,000 to bond. So that's could be somewhere between $350 and $1,000 for the year to cover 2 megawatts. And each megawatt is going to generate energy that's worth somewhere north of $200,000 and maybe $230,000 a year. And then we've done the calculation on that, and the bonding expense relative to revenue is relatively small at less than 0.5%. And the bonding, as much as we know of the fees that a subscription coordinator earns for managing the customers and administering and handling the billing, and we don't know all of that, but we have some general information. We don't believe that is more than probably mid-single digits percentage cost. So
Okay, but sometimes, it's the margins that make a project economic.
Understood, but the benefit. So these bonds, these are your guarantees that these entities are going to do a couple of things. One, they're going to adhere to our regulations for consumer protection. And there's a whole chapter of consumer protection for the community solar program that was put in place at the beginning and has been added to as we added.
But they would have to they would have to comply with that regardless of whether there's a bond in place.
This makes some skin in the game for that purpose. If you have a whole series of regulations, there's really no risk. You might maybe
Well,
not
but
put.
the risk is that they can no longer participate in the market. So that's
That is true, but there are other kinds of risks. Now, there are financial risks because, customers are being billed. The subscriber organization has the customer's money. So when you look at a performance bond, those are relatively low, but we also have to deal with the fact that customers' money is involved. They're holding customers' money, they're billing them, they have their credit cards, they have access to their information. It's not just like, we're not worried entirely about someone that's a bad actor. No one's saying Arcadia is a bad actor, but there are risks. Like your data system can get hacked, and what would happen if somebody got a hold of all the credit card numbers for a number of customers? I mean, that's happened to me personally. It's a real pain in the neck. But one of the things that the bond is there to do is to say, hey, you know what? There's some risks. We really ought to maintain good security on
okay.
our
So
equipment.
would there be enough skin in the game if the bond amount is reduced? So that's the other question or the other request from Arcadia is accepting a bond but having the bond be smaller, so that is less risk for them.
One of the things, and it sounds like Mr. Spivak has an answer for that. One of the things I'd be concerned about lowering the scale that we deal with now, or perhaps capping it at some level, is that we don't really have a whole lot of experience with what could go wrong, and we've got what we believe to be a system that has worked and been in place for at least 3 years for the subscription coordinators and more like 7 or 8 years for the SOs. So yes, you could save a little bit of money and maybe improve margins for the participants, and maybe that will attract more, but I think we have a whole lot of people very interested in our program right now, as is. But our concerns with that is you may be removing a critical sort of incentive or disincentive perhaps, to do anything that would put customers' money at risk, their information at risk, or generally we also no one said anything. Arcadia's been great. They've been been participating. They've been a member of our working group, but there could be other entities that would be affected by this who are bad actors who might try slamming somebody or doing something that's different. We've got to have adequate bonding in place that protects customers from a wide variety of potentially bad outcomes. And it gives confidence to customers when they call up, the utility and say, should I sign up with this? Who are these people? The utility can say, look, do they have a number on their materials? What is it? Okay, we can tell you who that is. We know that they are an authorized and bonded entity. It is safe to transact with them.
Okay.
And I would hate to weaken that.
Okay, thank you.
I just wanted to add on a couple of those things. With respect to market entry, certainly the experience we've had to date is that we've had pretty robust market entry and a lot of participants in the community solar program, so the bonding requirement as it is does not seem to have retarded that. So that's one element. The second thing I would just like to note is that when all of this started back in 2017, staff had advocated for a flat bond in the amount of $250,000, like as we impose on general electricity suppliers. And at the time, Earth Justice had made the proposal to do a scaled bonding requirement that the commission ultimately adopted, and that's currently in place. And I think we've come to see that as being a very well-structured bonding requirement. The fact is that the amount of the bond and the amount that the individual subscription organization or subscription coordinator is going to pay is dependent entirely on how much capacity they represent or have in Maryland, and the number of customers that they consequently have as well. So having that scale is a very useful thing.
Okay, thank you.
Commissioner
Yeah, I'm interested to hear from the company, from Mr. Wallace, but I guess I'm just still trying to understand these risks and how these are measured. This bond is measured toward these risks. I mean, at this point, there's a requirement that if you sign up for community solar, you're going to automatically just get a 10% discount. Is that correct, off of the going retail rate?
Yes, that's
Okay,
about
so
right.
that's what the customer, and that's going to be in place no matter what. I guess what I've just heard now is the one risk is a breach, I guess, of a computer system, and so the bond is somehow going to be funding to address that type of risk. Is that the risk that we're concerned about now?
That's just one example.
Well, I just want to understand what these risks are, and if, as Commissioner Suchman, asked, about other states, other places that have really good programs and programs that are successful. Why aren't they also, trying to because my concern here is, are we just burdening this program, a program that has been mandated by the legislature, a program that we want to see succeed because we need these energy resources in our state. We want the clean energy resources. It's I think the most just way to get all Marylanders an opportunity to participate. And so again, I just want to be sure staff has thought through what we might be doing to potential program. You say it seems that it's okay. That's not good. We have a major provider, major developer that's here saying it is a problem. So again, what are these risks and how are they measured, this amount of collection measured against those risks?
I'm going to let Mr. Vanderheyden answer this.
Your Honor, we have had discussions on and off about bonding with both SOs and SCs over the years of the program. We understand that it is a cost. We believe we have a handle on what that cost is. From our read of the Arcadia complaint, they are looking at the size of their bond, and they're reaching a point where they're having some concerns about being able to acquire a bond for that. Now, bonds do scale premium with size. You're riskier if you're at $1 million than you are at $100,000.
I just want to make sure we're not layering bond upon bond here. And what additional
There's only one
protection
bond.
are we trying to find?
We are trying to assure customers that regardless of the scale of the program, the level of protection they have, be they with a small SC or an SO or a large one, is the same. The financial amount of the bond scales with the program, and that's a wise choice. The commission actually directed that back in 2017 when we established the way the bonds work. Smaller entities in the program provide bonding at a percentage level that's the same coverage as you would with a large program. If you have 100 megawatts and you have 2 megawatts, relative to the amount of revenue you're dealing with, it's the same proportion. If you try to cap it, or if you try to reduce it at the higher end in order to shave some margin off the expense of the program, or if there's some issues with using a single bonding company, you're going to reduce those.
You're going in a direction I'm not asking about. What's it for? And I don't think
What's the bond?
I want to hear from the company really where we're going with this, because again, I feel like since the inception, we've made it very difficult, and some of the difficulty has come from this commission and how we've put together rules. And I just want to make sure that we are helping this program that's been mandated by the legislatures succeed. And again, I just worry one more time we're here, we're hearing from a company that says, hey, you're adding unnecessary costs and you're inhibiting the success of this program. So,
Your Honor, I think you can be assured that this commission has done a tremendous amount to make this program successful. All the rulings coming from this commission.
yeah, no, I hear that.
100%.
I just, I'd like to think I was part of that, and part of some of the rulemakings, trying to lift some of these, these problems, these concerns off of the programs. So, anyway, I don't think I have any more questions for staff. I just would like to hear from the company.
Mr. Barbe, anything?
I have questions for the company, not staff.
All right, so before I turn to OPC, let me just check. Is there anybody here on behalf of what I described as the undersigned subscription coordinators who filed something in this? All right, seeing no. Anybody here on behalf of the Coalition for Community Solar Access and the Chesapeake Solar and Storage Association? All right, seeing that. So, OPC.
Morning, Chair Hoover and Commissioners. Brock Miller on behalf of the Office of People's Counsel. At this time, OPC opposes Arcadia's request for the Commission to reduce the company's bond requirement to a fixed $100,000. As explained in the letter that OPC filed and reflected in other filings on this matter, the current bond requirement formula doesn't appear to be tied to any evaluation of the role that SCs play in the community solar model or any risk involved in those roles. As Arcadia noted, there are some differences between SCs and retail suppliers, but SCs do still have customer interactions that last a lifetime of community solar subscriptions. As staff noted in its buck sheet, Arcadia has received at least 31 CAD complaints over the past few years, stemming from the company's interactions with its customers, including unauthorized enrollments. Any change to the SC bonding requirement formula should be based on a fuller evaluation of the relationships between the SCs and customers, as well as the SOs, utilities, and the Commission. Also, though some letters filed in this matter appeared to construe the company's request as a request to modify bond requirements for all SCs, it's important to note that Arcadia's request here was for a modification only for its own bond requirement. Just as the Commission shouldn't modify the bond requirement formula without any evaluation of the role that SCs actually play in the market, the Commission also shouldn't modify the bond requirement for Arcadia alone. Therefore, if the Commission is concerned, which it appears you are, about the current bond requirement formula, OPC recommends that the Commission delegate the matter to the net metering work group to develop any types of recommendations the Commission might be looking for. Once the Commission has those recommendations in hand, then the Commission could revisit the issue and decide whether to modify the bond requirement formula for all SCs across the state. Thank you, and I'm available for any questions that you might have.
So, questions for OPC, Commissioner Richard? Barbie?
So you're in agreement that this needs to be looked at, and you think we can do this expeditiously through the net metering committee?
So I think
Work
OPC,
group.
OPC does agree that it should be evaluated, if only because it doesn't seem the original formula was based on anything in particular other than just applying the SO formula to the SCs. As I think CCSA mentioned in their letters that they're not here, the net metering work group is quite busy with the implementation of lots of recent bills through our regulatory process. Mr. Vanderheyden might be more available to speak about how tied up the work group is, but I think it's something important that should be looked at beyond just the scope of one admin meeting.
Okay, yeah, and that's something then the commission could order, it just like, please take this up expeditiously, and, because I tend to agree with the position of OPC that it needs to be uniform, and but we do need to make sure it has a purpose, and it's not inhibiting the program at all. So, thank you.
Correct.
Thank you, Mr. Chair.
I would note that staff also said in our comments that if the Commission is inclined to revisit the bond issue, we would want to do it in a way that covers all of the SCs and not just Arcadia as well.
Okay. Commissioner Barbie.
My question's for the company.
Commissioner Schlesman.
Morning, Mr. Miller. So I'm still not clear about the fact that there are distinct liabilities when we're dealing with both an SC and an SO in a relationship. I'm assuming that there are some distinct liability challenges when an SC is going out and trying to find customers. So that does sort of make sense to me. Once the relationship is established, where might there be exposure for a residential customer in that situation that would necessitate a bond?
Sure. So, to read your first instinct about the difference of who's going out and actually finding the customers, I think is an important distinction to make. And without looking in detail at all the CAD complaints that staff pointed to, there do seem to be some complaints for unauthorized enrollments, which might continue to last for some time until the customer realizes that they've been enrolled without their awareness or permission. So that could go beyond just the initial looking for customers. There have also been some billing disputes. I'm not sure if that would be ongoing. Now that we're also moving to net crediting and utility consolidated billing, that might change that dynamic, but I think we need to look at it more carefully. And the misrepresentation that that was the basis for some of the complaints also, probably is an earlier on type of complaint. So I'm not sure that there are any significant, pressing, long-term issues, but I think that it's worth looking at and not making decisions standing on one foot.
Right, but it seems like there's certainly a need for some bonding.
Correct.
Then the question is the size of the bond.
Yes, I mean, I think that's
Okay.
other states, have different approaches. I'm not sure if the relationships laid out in statute or regulations in those states differentiate the relations between SOs and SEs differently. I think it's worth looking at, and that's something that should be considered in any evaluation that we do on how we should move forward with the
Okay.
bond.
If I might also add there, I mean, there is, at least from what we've learned from Arcadia, for example, information that indicates that the SCs have ongoing and continuing relationships with customers. At least some of them do. And so, that in some way or other could develop liabilities. The other thing is, the bond, we had the question with respect to bond redundancy, and the only way really an SO's bond could work for the SC is if the SC is acting as formally as an agent of the SO. If there's some relationship there that puts them in the legal position of an agent, and that is very clearly defined, that might enable somebody to draw on the SO bond for actions of the SC. But, again, we're not very clear necessarily on how these arrangements are worked out, and also it may be different from, between the various companies. There are a whole lot of SOs out there. There are at least a dozen SCs, and the relationships between them can be very variable.
Okay. Maybe Mr. Wallace can address that as well. Okay. Thank you.
Thank you.
All right, so one question for me. So your filing indicated that you opposed Arcadia's request. However, I interpret from your suggestion that if this goes to the work group, that you're at least open to considering making some change in these bonding requirements.
Correct, Your Honor. OPC's comment that we oppose the request was based on the filing that we interpreted to mean to redo the bond in this admin meeting, and that was what we were expressing opposition to.
Okay, all right. Okay, so let me turn to Arcadia.
Good morning, Chairman, Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of Arcadia. We filed this request last year as, Arcadia was growing to a scale where, in discussions with sureties, the bonding was becoming more of a challenge than it had historically been. As we are transitioning from the pilot program to the permanent program, I think the structure that was implemented under the pilot program is worth revisiting. This is absolutely a market issue. It's not just an Arcadia issue. Our filing was focused on addressing the immediate issue that Arcadia is looking to resolve here with respect to its bond, but Arcadia supports a market solution that, and I think staff and OPC and everyone means well in terms of aligning ensuring that risks are properly addressed. I think when you look at this structure, we haven't been able to determine what the risks are that staff is concerned about that are going unresolved here. This bond is, this double bonding structure that we have for community solar is unique to Maryland. Across, there's 14 or 15 other jurisdictions that have community solar programs. Many of them have some kind of a project bonding component for the capacity. None of them have a subscription coordinator bonding. Certainly not one that scales at the same level as the project. And I think importantly in COMAR, the Commission has robust consumer protection rules. And one of the key rules is that the subscriber organization is responsible for the actions of its subscription coordinators. I can pull up that particular COMAR, but it's not just a kind of an opaque potential agency argument that the Commission would have to make. The Commission spelled out in its in its regulations, that's Comar 2062-0515, that a subscriber organization may use an agent or subscription coordinator to conduct marketing or sales activities, and a subscriber organization is responsible for any fraudulent, deceptive, or other unlawful marketing performed by its agent or subscription coordinator while marketing or selling subscriptions on behalf of the subscriber organization. And when the subscriber organizations go to register a project with the utility, they identify, at least in the BGE and PHI platform, you identify who the subscription coordinator is that you're working with. So that information is tracked, and then we have this regulation that holds the subscriber organization accountable. So there's right now, for every megawatt of capacity, there is a 10,000. There's a bond for 10,000 for the first megawatt plus 25,000 for each additional megawatt times 2. And then another issue that's come up, I have some clients that are interested in becoming involved in the space and performing some marketing functions, and we're having discussions about whether triple or quadruple bonding will apply. If Arcadia is working with another vendor that is also wants to come in and get registered, we could be looking at kind of continual growth here. So this structure is a problem for the market. I think all the comments that came in supporting Arcadia's proposal here reinforce that. And when we were talking about the cost side of things, it's not just the premium that's an issue here for Arcadia and for others. Arcadia has gotten to a point with its bond where sureties are looking at this, having trouble understanding what the risks are in the context of their work with other community solar providers in other markets, and looking at the additional bond that the subscriber organization has. So there's some confusion about what this bond is doing, even among the sureties. And there's a cash collateral requirement that's kicking in that's really triggering Arcadia to make this filing. So it's not just that you're paying a small percentage of the face value in premiums each year. They're asking for, I think in our filing we flagged, and some of this information is confidential, but a substantial amount, right, of the face value of the bond as cash collateral to be paid and held by the surety in order for them to issue bonds above the current level, which is many-fold above what the commission requires of a broker type entity on retail supply, which is a $10,000 bond, regardless of how many customers you serve. So when you look across the Maryland bonding landscape at the commission, there's a big misalignment here. When you look at Maryland compared to other markets for community solar, there's a big misalignment. And and the cost of the bond, there's a lot of factors that go into that, right? Sureties are looking at the balance sheet of the company, the scale of their business, their operations, and making a judgment about how much to charge for the premium, right? Everybody doesn't pay the same thing. If you have a big balance sheet, your premium will be a lot lower than a smaller company that's entering the market that'll pay a much higher premium. And then you also have additional cash collateral requirements that kick in depending on the scale of the bond. So there are a lot of issues in terms of the cost beyond just, a small percentage that scales indefinitely. That's just not how the bonds are structured for Arcadia or for the other providers in this space. So, Arcadia supports a market solution. Our request was that the commission, modify the bonding structure to $100,000 and set it at a flat level. We support doing that as a kind of market-wide solution. If the commission's not inclined to do that today, perhaps the commission could issue an order, kind of providing a temporary bonding reduction to that level, or keeping Arcadia's bond the same pending a further discussion on this, either in the net metering working group, or we would support if the commission were to schedule a legislative style hearing in a few weeks and give market participants an opportunity to file comments and come in and talk to the commissioners about all of the different kinds of questions that we heard from the commission today about this bonding structure, and then make a decision about what the right approach is going forward, considering what the potential risks are, how those risks might be addressed by the existing bonds for subscriber organizations, the transition of the program into the permanent program phase, and the adoption of net crediting, and what that means in terms of taking the billing function and moving it over to the utility. One of the other important things about this market, community solar is a savings product. in terms of the way the money is exchanged today under the pilot program, and this is going to change within that crediting, but my understanding is that when the credit is applied to the customer's bill and they see that discount, that then triggers the invoice for that benefit that they've already received. So it's not that the subscription coordinators are out collecting money in advance and then, the customers are getting left holding the bag if there's a billing issue, right? They get their credit on their bill, reducing their utility charges first, and then they get an invoice for that benefit. And that's something that has evolved because, that's what works best and that customers prefer, so that, you're having an alignment of the benefit with when you're being charged for that. It would be a really bad customer experience to get charged in advance and then those, waiting for those bill credits to appear down the road. So, all of that is, I think, it is important context to understand the big picture here. But what we're really looking for is, at least a temporary solution so that, Arcadia can keep, working in Maryland and growing its business. And then, a closer look at this structure as a whole, both on the subscription coordinator side. There's also some issues in terms of, the way the bonding is working for the subscriber organizations as well. But, it's some sort of a path to a market-wide solution for the long term as we head into the permanent program would be a great outcome for Arcadia and for the other parties that filed comments here over the last few days.
Okay, let me start with a process question. And you kind of alluded to this, but let me try to get more clarity on it. What is the time sensitivity for your client, at least, as far as fixing this issue if we fix it?
So they're continuing to, they filed this back in May of last year, right? They've been continuing to grow and add customers. And so now, and I think OPC flagged this in their comments, they've continued to add customers. Their bond has not been increased yet. And so we don't want to be in a situation where the commission finds that their bond is insufficient because this has been pending so long, and there's some sort of an issue there, right? Their bond is very large. It is, we think it is more than enough to cover whatever the risk may be. But if the commission were to say, no, you need to, update your bond today to match this, they're going to have to go out there, post cash collateral for a lot of money, look at where the market is now. It has evolved since May of last year when we made our filing, and we had some discovery with staff and OPC last fall as well on some of these issues. But so, we want to have a path forward that they can continue to grow, and then once the commission it makes a final decision on what the bonding structure will be going forward, they can make that update, whatever that may be, and move forward.
But I guess what I'm trying to get at is if we take up OPC's suggestion and push this to the working group, is there a concern that, that process is just too long to get to some determination and it's going to actually have some impact on the development of community solar?
Well, I think that there's a lot of interest in a near-term solution on this. So if it is going to go back to the work group, perhaps a timeline to say we want to report back from the network metering working group addressing these issues, right? What are the risks of the program with respect to subscription coordinators? What are the appropriate bonding structures to address those risks? What's talk about the cost side of the bonding, and what are the proposals going forward? And maybe there'll be a consensus that comes out of the working group. Maybe there will be some different proposals that'll come back to the commission for consideration. Another option is to just schedule a legislative style hearing, get it on the books, and have everybody just come present to the commission with their, what the proposals are there, and make a decision that way. But we would like to have a kind of a relatively near term.
Okay. So who's in charge of that working group?
Mr. Chairman, I'm the
Okay.
group leader.
So the first question is, there was some allusion to other stuff that the working group's working on. So, is the schedule pretty tight right now?
This issue, among a number of other issues, has been identified as what we'll be working on post this upcoming rulemaking. So this is among a list we developed and circulated to the work group last summer, and bonding is one of the issues.
But is there a way to sort of put this at the top of the list?
I mean, certainly, if that's the commission's desire, I mean, we're able to address that issue, as a priority amongst others. And we certainly have, typically we go to the work group and see what folks really are, what they want to address first. I would imagine, given the participants amongst the solar industry, they would tell us if there are other things they need to do first. But certainly that's kind of one of the benefits of having a collaborative working group.
And in the scheme of sort of, I know we're in the midst of this process of trying to set this thing up as a permanent program. Does it do a lot of, or any harm, if we decide to pull this issue out and have this legislative type hearing that has been suggested as a way of trying to resolve this thing apart from the working group?
I think it might, my attorney wants to say something. I would recommend that if there are technical details that we need to get into in sort of an open discussion, a working group helps to do that. A legislative presentation might not get you the back and forth that we would typically use to solve issues technically.
Okay.
Yeah, I just wanted to add, we actually had this discussion internally in staff and whether it would be a good idea or not to have a generic proceeding and do it that way. And I think we came to the conclusion that, as matters currently stand, there isn't necessarily enough factual information and detailed working through the issues to know what we would present you with at a during a generic proceeding. And our conclusion was that it would be much better to work through the working group and get people to solidify their notions of what they actually want, what they think is actually needed, and and provide a lot more information going back and forth between the stakeholders before actually then having some kind of generic hearing where they could present what they'd learned and what their an informed opinion on what the commission should do going forward.
Okay. All right, so let me turn to everybody else. Commissioner Barve.
Yeah, thank you, Mr. Chairman. So I have really only two questions. Staff has basically made the argument that the bonding requirement is very low and shouldn't have an impact upon your business. Please make the counter argument to that.
Yeah, well, I think the counter argument is that it's actually very high when you look at the related bonding requirements, the duplicative bonding between the subscriber organization and the subscription coordinator for the same customers and the same projects. And then when you look at compare Maryland to other markets where this subscription coordinator bonding requirement doesn't exist, much less at a level that scales at the same level as our subscriber organizations pay for multi-million-dollar projects that they are operating over the long term. And I think also when you look at the fact that we're moving into the permanent program and the billing function is shifting, that's a big area of potential issues. And that billing function is going to move over to the utilities. So subscription coordinators are not going to be, handling money, processing money like they may do today. I talked a little bit about how it's a bill credit first, then the invoice structure. So that's, I think, mitigates some of that risk anyways. And when you compare the current bond for electricity and natural gas supply brokers at $10,000, and then you look over at Community Solar, a guaranteed savings program, certainly with respect to Arcadia, with respect to everyone else under net crediting going forward, we can't understand what the risk is that would necessitate any bond in addition to the subscriber organization bond, much less a bond of this level. And the real big concern is when you get to a certain size, and Arcadia is there now, sureties are coming back and asking to post, what is going to be multi-millions of dollars of cash collateral with the surety to back up their bond. And that just doesn't make sense financially, especially if we can't identify what risks we're protecting here against with that bond. So, Arcadia wants to make sure that, we proposed a $100,000 bond. That's 10 times what brokers and for electricity and natural gas, provide. We think that's a reasonable outcome here. If there's some other number north of that that the commission lands on, I mean, we can make that work. But just the current structure that grows indefinitely and is starting to trigger these cash collateral requirements, and also potentially higher premiums.
How much are these cash collateral requirements?
I mean, 50%, right? So if you have a bond that, as we get into, 100 megawatts or more of project capacity, we're talking about, I mean, Arcadia, I'm not going to get into the specifics because it's commercially sensitive, but, bonding requirements that are, cash collateral requirements that are going to be in excess of $1 million shortly, potentially as an outcome of this discussion, and then we'll grow from there. And then their competitors, especially smaller players that are entering this market that may not have as much, as many projects, as much experience. Sureties may require more cash collateral and earlier. In prior discussions with sureties, the Arcadia team was hearing that they wanted 100% cash collateral. That they've walked that back a little bit. But if a smaller player wants to come into the market, they're going to pay a higher annual premium for the same bond amount.
And so you're arguing because of the complex nature of underwriting in this market, that's what's driving the cash collateral requirements?
The underwriting nature of the surety bonding, yes. And it's all based on the balance sheet of the particular applicant and the risks of the program. And it's hard, to quantify what those are. But sureties are not comfortable continuing to issue larger and larger bonds. And so that's where we're seeing those cash collateral requirements come into play.
Okay, I think you answered both my questions. Thank you, Mr. Chairman.
Representative Richard.
Yeah, I think you covered most of what I wanted to ask in your presentation, but just again, so I'm trying to, like you, I'm trying to understand why we're having this double bonding situation in the first place. The SO is responsible, if I heard you correctly, for the SC, for the. Does your client use I can't say a subscription coordinator?
So Arcadia is a subscription coordinator. So
Okay.
they work with a whole bunch of different
Okay.
subscriber organizations.
I see.
And
Okay.
and they facilitate enrollment of subscribers to those subscriber organizations projects. They handle a variety of service functions, similar to kind of like a broker would do. So they're reaching out to customers, they're helping connect customers to projects, help get them enrolled, help coordinate with the utility, those kinds of functions.
Okay, yeah, that's helpful for me to understand. Just because in my experience, it was actually had to wait in line, to get into the program, and so and then as you mentioned, I get an invoice. So for the most part, if I get suddenly an invoice for something, that would be, I guess, my first indication that something is amiss. But if it's a rogue organization, I guess any bond requirement is not going to stop that from happening. Is that correct? I mean, what?
I mean, if there's a company that's not going to follow the commission's rules,
Yeah.
the bond requirement, is not going to stop that. I mean, I don't think the bond requirement is necessary though, because subscription coordinators are entering into contracts with subscriber organizations that are owning and operating, making a massive investment in, solar facilities that they're building in Maryland under the commission's, regulations and oversight in this program. And if they hire a subscription coordinator that goes AWOL, that creates a ton of risk for that project. And those projects have bonds on file with the commission for that capacity. So in the event that there's an issue, the commission can go after the subscription coordinator, can also go after the subscriber organization, and right now there are bonds in place on both ends. We don't think that's necessary, and certainly not at the level that we have today.
Okay, and then on this question of fairness, right now I think I understand you saying that your bond has not, that you haven't received any requirement from the commission to increase your bond at this point. Is that correct?
Well, I think that there's some gray area there, right?
Yeah.
So if the commission, directs that the bond structure will continue to grow with capacity, then, as Arcadia, is routinely going out and enrolling more projects, they're going to need to come back and make updates and update their bond. And we're at that level now where they're going to, they're hearing from sureties that a cash collateral requirement is going to be necessary.
Okay,
Right?
so,
So what we're asking today is that the commission, temporarily say your bond, your over $1 million bond is sufficient for now. We're going to take a closer look at this, either through a networking group process or a legislative style hearing, and then as a result of the outcome of that proceeding, we're going to direct Arcadia to make the appropriate updates to the bond at that
okay,
time.
so one thing we could do is do nothing. Just say, let's stop any increases in bonds or requirement for new bonds pending some kind of a process to come up with a market solution.
That would be a good outcome. Yes.
Okay, and as far as the fairness issue about some of these other SCs that may have higher bonds, higher than what might come out of this market solution, I mean, is there kind of a remedy there?
Yeah, I think an order that were to apply that kind of an interim bonding resolution to the whole market, not just to Arcadia, to say subscription coordinators, whatever bonds you have on file now, keep them there, and then as a result of our closer look at this bonding structure, we're going to direct that each subscription coordinator go back and cancel their bond, revise the bond face amount to increase it or decrease it, or some combination of those structures. But I think something, a letter order from the commission, that kind of provides an interim solution to this, so that subscription coordinators aren't wondering what they need to do. Do we need to immediately run out and update our bonds? Are we out of compliance? I think there's a lot of questions about what's happening with this bonding structure going
Okay,
forward.
so when, like today, we could just say freeze in place, and then let's have some kind of a process to move forward as far as setting coming up with a market solution would be
Yeah,
something
that'd be a reasonable outcome.
okay, terrific. Thank you, Mr. Chair.
Commissioner Sussman.
Okay, so Mr. Wallace, I'm still confused about where the liabilities lie. And so I'm assuming, I mean, you read the COMOR provision that provides that where an SC operates as an agent for an SO, the SO is responsible.
So yes, but I wouldn't say it's where the SC operates as an agent, right? So the agent is a separate definition and an entity type in the regulations. So, for example, Arcadia could have an agent, right? That is under the COMAR that is operating under Arcadia's name, right? So they subcontract some function to an agent that is doing something as Arcadia. Let's say it's a door-to-door sales vendor, right? They come and say, I'm with Arcadia, here to talk about community solar. They're acting as an agent of Arcadia. That subcontracted vendor or individual wouldn't have their own subscription coordinator certification. Where the subscription coordinator certification kicks in under the definition of the statute is if you're providing marketing services in your own name, right? So Arcadia isn't coming in on behalf of developer ABC to talk to customers. They're saying, I'm here with Arcadia. And so that's where the commission has the subscription coordinator entity that's coming in, getting certified, getting its own certification number, and as a result of the current structure, also posting a bond with the commission. So,
Right. No, I understand that. What I'm trying to understand is the contractual relationship between you and the SO.
Yeah.
Does Arcadia have a contract with SOs in which you lay out the liability the liability for the SO to the extent the SE behaves in an unauthorized manner?
Yeah, so there are contractual arrangements. I can't speak to the specifics of exactly the way the two parties, Arcadia and a subscriber organization, allocate and indemnify and allocate liability.
Yes. See, and this to me is really the crux of the matter. Is, for example, if you're behaving in a way that is unauthorized in the contract, so that you're operating extra virus, then the SO can argue that they are not responsible for your behavior, and therefore whoever is going after them, you and them, the argument is that you can't reach the bond because you're operating in a way that is not consistent with the contract. So even in that scenario, the bond that the SO is holding may not satisfy the party that has been injured. And so even in a situation where you can argue you're only operating as an agent, to the extent that the agency relationship is challenged, then the residential customer who's bringing the action is without recourse. So I'm just, I mean, unless we make it extremely clear that an SO is always responsible for anything that happens, you're going to have some bonding requirement for the SC. Do you see what I'm saying? I mean, because I understand where you're going, and that, it's certainly cleaner if we just say, SCs always operate on behalf of SOs. SOs are the only ones that have to carry the bond, and you can always go after an SO if there's a problem. That would make things a lot easier, and you wouldn't need the two bonds. The concern I have is a situation where the SO argues, well, we didn't tell Arcadia to do that. They went off on their own. They're not really acting as our agent, and then the residential customer who signed up has no recourse. So, I mean, unless you can answer that question, I think we're still in a situation where there's still going to be a bonding need, unless you can make it clear that any time there's a problem, that customer can always go after the SO bond.
Well, I think we have Comar 2062-0515 where the commission has said that the subscriber organization is responsible for any fraudulent, deceptive, or other
For its agent, but what happens if
or
the
the subscription coordinator?
Right, but if the SO, if you're behaving, you as a subscription coordinator are behaving in a manner that is not consistent with your contract, or you've sort of gone out, you don't even have an SO. You're an SC looking for customers, and then you're going to go find an SO. Is that a possibility?
It's a possibility.
Right, and see, this is where I think. I mean, maybe this is something that you can sort of take up in the work group, but I unless you can nail down the potential liability challenges, I think you're going to have some kind of bonding requirement for the SC, which is forward facing. They're the ones that are out there with the customer. Customer only knows the SC. They don't know the SO.
And I think we're okay with a bonding requirement. We proposed 100. There may be another number that works well. I think if we can get, kind of a revised structure, Arcadia certainly is open to.
Yeah,
an ongoing.
I'll tell you, if you take this back to the work group, I really would like to get some clarity around who's liable for what, because I'm still, even with what you read in Comar, I'm still not clear that we've sufficiently nailed this down to protect residential customers.
If I add something there, with respect to the Comar that Mr. Wallace referred to, I mean, listening to what he read out, my thought was that it only seems to apply at the point in the transaction where they're doing the marketing, they're doing the solicitation for the subscription. It doesn't seem to apply after that, the way the language read and sounded. So that was one opening in there, and it also seems to contemplate that the end of the subscription coordinator's relationship with the customer is when they've passed them on to the subscriber organization. And from what we've heard from Arcadia about their business model, that is not it. They have an ongoing relationship with the customer where they're actually involved in the monthly transfer of.
Well, and this is why I think it would be helpful to have some clarity about responsibility. So and it may be that you can find a way to just have the SO be responsible in all of those situations, in which case maybe you don't need the SC to have a bond. But it seems to me that unless you can figure out all of those different possibilities, we're still going to be a situation where the SC is going to have some kind of bond. Okay, that's all I have.
Okay, so, anybody want to make any concluding remarks? Although, let me tell you, we're actually not going to issue anything today. We're going to take this under advisement because there's, to my mind, a lot of moving parts here, both the substance of this issue and how we fix it. So, so if you got any concluding thoughts you want to offer before we take this back in the back room and figure it out, go ahead. Let's start with you.
I think we'll leave it to rest at that. I mean, staff is satisfied with the functioning of the existing bonding requirement, but if you are inclined to do something with it, then it probably should go to the working group.
Yeah, the only concluding remarks I'll give are just in terms of what we're looking for as a resolution, and kind of echoing a couple of points Commissioner Richard and I discussed. You know, an interim solution so that folks know that the bonds that they have in place are going to be sufficient, and then a path forward to getting this resolved for the long term expeditiously would be what we're hoping to achieve here. So.
Okay.
And again, Brock Miller for OPC. Also, I mean, I think OPC, understands the need for an interim solution while all of this is being considered, and OPC wouldn't oppose some sort of freezing if that's what the commission deems appropriate in the meantime.
Okay. All right. With that, we're adjourned.